Okay, welcome to the second tutorial video by Elton Jenkins. This is called What is a Deferred Sentence? And I'm titling this The Second Best Thing That Can Happen to You in a Criminal Case. The first thing is you can always go to eltonjenkinslaw.com, and at this website you're going to be able to find almost everything you need. If you need to contact me or find out anything here, you can just type in here, and if you don't have an attorney already, then I'll be glad to answer any of your questions. You can also find all these videos at my blog. For example, the first one here, using OSCN to search a criminal case, is right here. Now for our presentation, what is a deferred sentence? The second best thing that can happen in a criminal case. For everybody who's been charged with a crime or has a friend charged with a crime, you've probably heard the term deferred sentence. Obviously, a dismissal would be a little bit better, but since those don't happen very often statistically, we'll cover those in a different one. The definition of a deferred sentence is a sentence that is set off for a specific amount of time and date to allow a defendant to complete a period of probation. If the defendant fulfills the stipulations surrounding probation, a judge will allow the defendant to withdraw the plea and dismiss the case. This is coveted by most criminal defense attorneys and criminal defendants because the sentencing date does not actually happen for some time in the future, and since you aren't sentenced, you do not have a conviction, which is a very big deal. I've put a little chart on here. This is a timeline on a 5-year deferred sentence, and this is if you're successful, how it works. For example, if today you entered a guilty plea or a no contest plea, we'll go over that in a different tutorial, the sentencing date is going to be set off for 5 years. So you are not actually sentenced today. You're put on rules and conditions of probation in order to do those, and you're agreeing to do those. You're going to waive a trial, jury or non-jury trial, and then during this time between today and the 5 years out in the future, OSBI, which is where you get your criminal rap sheet or your background check, it's going to show pending but not a conviction. In 5 years, when that date comes up, if your rules are completed, that's great. The judge is going to withdraw your guilty plea and is going to dismiss your case, and they're supposed to expunge it. And what that means in Cleveland County or any of the other counties here in Oklahoma, that record will be sealed, meaning it's going to be put into a place where nobody can get it without a court order. And the big deal for you is that you cannot see this on OSCN, which is the first tutorial where all the dockets are. OSBI is going to show that the case was dismissed, but is still going to have the arrest and the charge listed on there as an agency action. Following that, in 2 years or 10 years, depending on, and this is complicated, we'll do another tutorial on this, you qualify for a full expungement, which is going to allow even the record of the arrest or the charge to be taken off of your record. You need to talk to your attorney about this. And then at the end of your deferred sentence, if you can tell that it is not off of your record, you can still see it on OSCN, you need to talk to your attorney. For a small fee, the attorney can usually get that taken care of. This is a 5-year deferred timeline. If you are unsuccessful, it starts off the same, guilty plea or no contest plea. Your sentencing is going to be set off to the 5 years we talked about before, rules and conditions, and you're not going to have a trial. But in the meantime, if you do something that you were supposed to do or not supposed to do, either a new crime or a failure to get something done or show proof that you get something done, this date that was set off 5 years, the state is going to move the court to try to accelerate it, which means move it up. They get to have a hearing, and if they can prove or you confess that you violated the rules and conditions of probation, you can be sentenced to anything that you could have been sentenced on the first day. So, for example, a possession of methamphetamines carries 2 to 10 years. You could have gotten a suspended sentence, so if they can prove this, you come up for sentencing, you still could get 2 to 10 years, and you still could get all, some, or none of your case suspended. So anything that could have happened here can now happen here. If they can't prove it for whatever reason, you're going to return to your probation. They're going to fail on their motion to accelerate, and this one right here is important to defense attorneys. We try to stall until all of your rules and conditions are met. If you just fail to get something done, eventually the judge gets frustrated and tries to put you in jail. But if we can stall until you get your treatment or your 40 hours community service or whatever it is, we're asking the DA to be nice and dismiss this motion to accelerate so you can still remain on your 5-year deferred and still get your expungement and dismissal. Who cannot get a deferred sentence? If you have a previous deferred on a felony statute that makes it look like you can't get one, although that's debatable. Some judges will give you one anyway, but it's a pretty good argument, and you can go ahead and count that you've had a deferred sentence before. You're not going to get one again. Any sex crime that requires you to register as a sex offender, and that's not the facts of the case, that's the name of the statute that you either pled or were found guilty on. Doesn't matter what the facts of the case were, or if there's mitigating stuff. It's whether or not it is a crime for which you have to register as a sex offender. If you're found guilty at trial, there's no bar to a deferred sentence here under the statute, but you can count on a judge never giving you a deferred. If you choose to go to a trial and they even give you a $1 fine or 1 day in jail, you're going to get that conviction, and a judge is not going to go against that, mostly for political reasons, because you don't want to go against 12 people who are voters in your community, so don't count on it. Next one, when the facts of the case would cause no judge or prosecutor to allow it. I put these examples, probably makes sense once you see it: crimes involving children, violent crimes, and defendants with extensive records. If you got these things, even though there's no bar to it necessarily, you're probably not going to get one, unless we go to this next page. Getting a deferred sentence anyway. This is when you are barred by statute or when it's not likely to happen. Most of these are going to require a DA to waive the prohibition against a deferred sentence. First one, cases in which the prosecutor is likely to lose. This is where your attorney comes in. This is going to be the strength of the case, or if we have any defenses, you need to work closely with your attorney to try to really push this one, because even if you have all the reasons why you should be punished, if it's a case that they think that they're going to lose, then they're going to try to just get something out of you, which is sometimes a deferred sentence. Cases in which the alleged victim convinces the prosecutor to waive. These are going to be in your domestic abuse type cases, assault and battery type cases. If an alleged victim comes in and says, no, he's changed his ways, we need to make a family, many reasons why this would happen, but if they personally talk to the prosecutor and convince them, great, we'll take the deferred even though it's barred. If all restitution is paid up front, this is going to be your bogus check, or whenever there's some kind of property damage. If all that can be paid up front, then what you're telling the DA is that there's a very good chance that they're going to be successful on probation, and the alleged victim in the case is probably a constituent in that county, and you know that since they are made whole, that probably not going to be complaining to the district attorney's office too much. If all rules and conditions have been completed before the plea, what this does is tells the DA that you're very serious about what you're doing. It also tells the DA that there's not a lot of chance that you're going to mess up or fail to do something on your probation because you've already got it done. But basically, if you can just keep your nose clean and not get any convictions or get any new crimes, then you're going to be successful. So this is a really good tool. Drug problem, go get your treatment now, have it done before the plea. We're most likely or more likely to get the DA to waive this. And then finally, the witness cannot testify or will not testify. That dovetails with this up here, because obviously if they need a witness to testify and that witness doesn't want to testify or is not going to testify, it obviously makes it a lot harder for the DA to prosecute their case, which means it's more likely we're going to get that deferred sentence. Okay, that's a quick tutorial about deferred sentences. If you have any questions about this, please go to Elton Jenkins, Attorney at Law, right here, eltonjenkinslaw.com. This is the blog page, and you can see all these videos again. You can also subscribe to the YouTube channel. Just take a look at that. I'm sure you can find it. And then at the website, if you go to the home page, if you have any questions and you want to type them in here, as long as you're not already represented by an attorney, I'll be glad to answer any questions that you have here. So good luck, and be on the lookout for tutorial number 3.